Hello, everyone. Hello. Right, so hello and good evening. My name is Rossanna Yarleque and I am a litigator at Fahri LLP Solicitors. I have over, don't want to show my age, but over 15 years experience in the private rented sector. I operate nationwide and I do it all at fixed fees. So I want to talk to you about the Renters' Rights Bill and the changes to evictions. I think they were a little bit different order than what I had. So, Fahri LLP, we're based just up the road here in Whetstone. We deal with litigation, family law, private client, wills and probate, bridging, commercial, residential conveyancing. So even if you are fed up of being a landlord, get in touch with us because we can help you with the legals of selling it. When is the Renters' Rights Bill coming into force? Now, as David touched on, we don't actually know. There was a lot of talk about it coming into force around about October time. It is likely, I think, to be more 2026, so early 2026. But whilst that is not happening, I'm going to give you a quick whistle-stop tour of the eviction process right now. So, at the moment, we have Section 21 route, which I know they are going to get rid of, but we do still have it for the moment, which is your non-fault eviction. And then you have the Section 8 route, which is a notice for up to 2 months, and it's really just you want possession for a reason. Section 21 is the accelerated route. Please do not be fooled by the name. It is not fast. It hasn't been fast for many years, but it's the non-fault route, providing your paperwork is in order. It is what is known as box work. So providing you've dotted the I's and crossed the T's, you will get your order for possession. It's a 2-month-long notice. Once that notice has expired, you then apply to court. Providing the tenant doesn't put in a defence, you should then get your order for possession. Now, the order for possession is normally 14 days long, and after that time, if the tenant is still in place, the final step is the bailiff. Now, that process, unfortunately, takes around, as David also said, around about 8 months, sometimes up to a year. I hate to tell you this, but Edmonton County Court, even after you've done all of that, if you're waiting for a county court bailiff, we're waiting for 13 months.
Wow.
Not great. So at the moment, you've got Section 8. There are 17 grounds to that. 18 of them are mandatory and 9 of them are discretionary, and they are simply reasons as to why you want the property back. So, most common grounds. Landlord wants the property back for their own use, that's ground 1. Redevelopment of the property, that's ground 6. There are rent arrears, that's grounds 8, 10 and 11. Then you have breach of tenancy, which is ground 12, and then you have antisocial behaviour, which is ground 14. Now, all of these periods differ depending on which ground you're going on. For example, antisocial behaviour, immediate. Rent arrears, 2 weeks and up. Landlord own use, 2 months. I'm going to touch on the most common, which is rent arrears. Really, that's what most landlords suffer with, unfortunately. So those are mandatory ground, which is ground 8. Providing the tenant owes more than 2 months' rent, or 8 weeks' rent if it's payable weekly, or if the rent is payable 6 monthly or annually, they owe more than 3 months' rent, you can serve notice on ground 8. Ground 10 is a discretionary ground, that is that there is some rent lawfully due, and ground 11 is that there are persistent rent arrears. Now, at Fahri, we will always serve on all 3 grounds, and I'll give you a quick reason for that. Let's say the rent is, let's make it easy, maths-wise, rent is £1,000 a month. John, no offence to Johns, but John, your tenant, owes you, at the moment, £2,000, 2 months' rent. You serve them with a Section 8 notice on ground 8 because he owes more than 2 months. You apply to court, your hearing is a few months away, so now John owes you 5 months' rent. He then decides to pay you £4,000. He now only owes you £1,000. So he only owes you 1 month's rent. If you've only served on ground 8, you will not get possession because you've lost that ground. You only get possession if you've served on the other grounds, because that's your mandatory ground, is ground 8, that they owe you more than 2 months. If he If he owes you less than 2 months, you can still rely on grounds 10 and grounds 11 being they are persistently late with the rent and there is some rent lawfully due. So always cover your back and make sure you're serving on all 3 grounds if you're going for rent arrears. So, although Section 21 is going, and it's not fun, there are still going to be ways of getting possession. It's just that you're going to have to get possession via the Section 8 route. So, Section 8 is going to change slightly. Ground 1 at the moment is for the landlord to use the property themselves. So either myself or my husband who want to use the property. It's then going to be extended to family members. So you're going to be able to get the property back for your parents, for your children. That makes life a little bit easier. Instead of a 2-month-long notice, it's going to be extended to 4 months. Ground 1A is going to be added, and that's if the landlord wants to sell the property. Again, that's going to be a 4-month notice period, and you're not going to be able to serve that notice within the first 12 months. There will, as David touched on, there is going to be a restricted period of 12 months. So again, you're not going to be able to sell that property once you've served the notice. You're not going to be able to re-let that property, once you've served that notice for a period of 12 months. Ground 6, that's that the landlord wants property back to redevelop it. You are now going to have to show genuine intention. So you're going to have to even provide evidence of the plans. What are the actual works that you're going to do? And that's going to be a 4-month-long notice. Ground 6B is because, let's say, you don't have a license on the property. Therefore, you're not able to rent it. So really, you have to have the property, you have to vacate the property to comply with enforcement action. That is going to be a 4-month-long notice, and the judges are also going to have the power of asking you as the landlord to compensate the tenant for that inconvenience. Key changes to Section 8, Ground 8. Instead of 2 weeks' notice, it's now going to be 4 weeks. Instead of 2 months rent arrears, it's now going to be 3 months. And as David was explaining, you're looking at around about 4 months before you can even apply to court. And with the delays, it's not looking too great. Ground 14, however, is the threshold is lowering, so that's a little bit better. Instead of the tenant behaving in ways that are a nuisance, it's actually going to be whether the tenants are capable of behaving in a way that's going to cause a nuisance. So that threshold is slightly lowered. That's also going to be an immediate notice period, so you're not going to have to wait for weeks if they're straight away. Court delays. Now that is one that, as I explained, is not great at the moment. Barnet County Court is undergoing refurbishment works, so Willesden County Court are now taking all of Barnet's cases, or possession cases for the moment. I would suggest getting your ducks in line as soon as possible. I'm going to touch on a few problems that I find landlords come up with, and one is the contract. You would be surprised how many landlords I deal with that do not have a proper contract, whether it's a company let or it's a normal AST. Sometimes you don't even have the details on the back of a fag packet. You cannot do that anymore once the Renters' Rights Bill comes in. What surprises me as well is how much, how do I put this? Let's say I want to use your car, madam. Can I take your car for a spin? First thing you're going to ask me is, have you got a driving licence? Sure, I do. Have you got insurance? Yeah, of course I do. Yeah, okay, fine. But if I want to rent your house, I'm just going to pay you the first month's rent and the deposit, and you'll give me the keys. You're not really doing much due diligence there. And that for me is crazy. Your house is worth so much more than what's outside on 4 wheels, but you don't give it as much thought. Not just you. The other one is deposits. You need to make sure, obviously, that the deposits are protected and prescribed information is served correctly. You'll be amazed as to how many no-win, no-fee lawyers that are out there that will simply see, you haven't protected it correctly, great, let's help the tenant get their compensation. And it is pretty much as simple as going through a red light. Oh, I didn't know, I didn't see it, I'm so sorry, it was an emergency. Doesn't matter, you've not protected it, you're going to have to pay the penalty. You're going to have to pay some sort of compensation, which is anything from 1 to 3 times the amount deposit, and the deposit back. But not only is it 1 to 3 times, it's 1 to 3 times for each breach. So if they've been in there for 5 years, you're looking at potentially 15 times compensation. A lot of money. The other one is gas safety certificates. You need to make sure that your gas safety certificates are compliant. I've been coming across a few cases recently where the information of the landlord is not on the gas safety certificate, and that is actually causing a real problem, because technically that means that the gas safety certificate is not valid. Now, thankfully, the judges have been on my side when I've been arguing it, but it's not been an easy battle. And then notices. You need to make sure that you're serving the right notice, that it's the right notice period as well, and that it's served in the way that it's in accordance to the tenancy agreement. So if the tenancy says you've got to serve it by post, don't serve it by email. It's no use to anybody. And then disrepair. You cannot just give them the keys and forget about it. You need to make sure that the property is kept in a good state of repair. And keep records. Keep records of everything. If the tenant isn't letting the contractor in to do your gas safety certificates, keep a record. If they're complaining and simply not letting you go in there to fix these problems, well, how are you supposed to address this if they're not giving you access? Keep records. Which comes back to why it's so important to get a strong team behind you. You need a strong legal team, but you also need a really good managing agent. A managing agent who is going to keep on top of these things, who's going to have these records for you if you ever need them. Someone like Baker & Chase. Remember that this is an asset for you, but this is also the tenant's home. So you need to make sure that you weigh or keep the odds really in your favour. So that's me, a little whistle-stop tour. If there's anything that you need to do, please just come and chat to us afterwards. That's Rossanna from Fahri LLP.